I'm going to take the liberty of being moderator and ask a follow-up question. Earlier, Professor Shad, when you were speaking, you mentioned that it's possible that the Petroleum Development Act might be unconstitutional. Could you perhaps explain to people here who may not understand the term unconstitutional what the effect would be if the PDA
pull down the Twin Towers?
I think Tommy clarified it so beautifully. I wish I had talked to him earlier. So if petrol is found in Gua Musang, the federal government gets 5%. I think that's clearly unconstitutional because land is owned by the state. And if land is owned by the state, federal government has no right to 5% or 4.5% in my personal view. Unconstitutional would mean that the action of the executive or the action of Petronas or the law of parliament or the law of the state assembly is bercanggah dengan perlembagaan. It's in violation, it's in conflict with the constitution, and therefore it is null and void. Now, null and void from what date? On that the courts have some creativity. In some cases they say null and void ab initio, from the very beginning, from the date the act was committed. But in some cases the courts, taking note of utilitarian consideration, will say prospective, from the date of the decision. So basically unconstitutional means that the standard of legality, the test of legality is the Supreme Constitution. And an act of parliament or an act of the executive will always be tested on the litmus test of constitutional provisions.
Just one questioner.
I meant to answer this to Prof, but I didn't. I must say that it was not the federal government's case or Petronas's case in the Tengku suit that the PDA is unconstitutional, as Prof has argued. I think the problem with that argument would be that if you take it to its logical conclusion and for a court to rule that the PDA, and of course the court, only the court can rule because in its jurisdiction as under Article 4, the courts of Malaysia can declare an act of parliament like the PDA unconstitutional. So the power is there. And if the court rules the PDA unconstitutional, the first problem you have is that from 1974 till today, that's nearly 40 years, Petronas is illegal. So the birth and establishment and foundation and development of Petronas is illegal. And I think whatever we may say, Petronas is one of Malaysia's great success stories. And I think it will be a great tragedy. And I think certainly the parties that I represent, whether it's Unconstitutional, we all wish Petronas the best of health and may they make billions of dollars. We just want our 5%. So I think the first problem with that argument is Petronas becomes illegal. Second problem is, then what about the states and the agreements? And that leads me to argue why it's not unconstitutional, and I will explain where, if I understand Prof is coming from. Prof is talking about compulsory acquisition, the Gua Musang example and all that. But the answer to that is, if the states, the 13 states here, if the 13 states freely and voluntarily give up what was their right prior to free and voluntary relinquishing in a bargain, that is absolutely constitutional. And that is the beauty of the PDA. And I think Tengku Razaleigh, if he had more time, he can speak for hours on this, because I've heard Tengku Razaleigh when I went to interview him as a witness. He's got wonderful stories. This whole thing is an exercise in federalism. Tun Razak was worried that Sabah and Sarawak may leave Malaysia. We had difficult personalities like Mustafa Harun. You make him Minister of Defense, he never comes. You know what he's going to do. When you got Sarawak, you got Rahman Yaakob. All difficult characters. Then you got Harun Idris. So it was Malaysia coming out of the May riots, out of the NOC in very difficult circumstances. You had the Barisan Nasional form. PAS was part of Barisan Nasional. So to me, the PDA is a wonderful example of federalism. But it required all 14 to sign. All 14. The federal government and the 13 government. So if, for example, let's say if finally one did not agree, then what you say is correct. That let's say for example, Kelantan didn't sign. Then Kelantan can say, you 13, so you 12 other states, good luck to you. I am sticking to my Merdeka bargain. But once the 13 states freely and voluntarily sign the bargain, and I keep saying it's a contract, it's a bargain, all the arguments about constitutional illegality disappears. And you talk about compulsory acquisition, the costs don't fix the figure. If you can say that cash payments is an example of compulsory acquisition. And the cost, it's not the cost job to say, well, actually 5% is too little, should have been 12% or 1%. Back to adequacy and sufficiency of consideration. That's not the cost job. If you want to look at it from Article 11, 12, 13 and compulsory acquisition, an argument can be put forward constitutionally. Cash payments equals compulsory acquisition payments.
Well, I think this is a debate that might go on for
I totally agree that Petronas has done a great job. I enjoy going to Putrajaya and I like the view of the Petronas towers. So I'm not saying that Petronas should close down, but there is a constitutional issue. And basically what you are saying is this, that in the interest of the economy and broader public interest, don't ask such silly questions. That's what you're saying. Tell me the contract came afterwards. That I'm sure you are aware the Petronas Act was passed first, then it took a few years for the agreement to be signed. At the moment the Petronas Act was passed, it took away from the state. The language is quite powerful, you know. Basically, the Petronas is acquiring absolute rights to petroleum farm anywhere, offshore or onshore. But under the Constitution, the states have a right to that. So I think there is a problem of unconstitutionality. I pray with you that nobody will ever ask this question.